We are live. All right, good morning. It's April 22nd, Senate Judiciary. We're getting a walkthrough of page 642, and we have lead counsel here. The floor is all yours.
Thank you. Good morning. Eric Fitzpatrick from the Office of Legislative Counsel, here to do a walkthrough of page 642, as the chair said, on activating the youthful offender proceedings. A quick moment of background just to remind everybody what the youthful offender process is. You remember it's essentially a middle ground between a juvenile proceeding and an adult criminal proceeding, so that when a young person commits an unlawful act prohibited by the criminal law, under the current structure, the person could conceivably be charged as juvenile in the family division, depending on the age. It always depends on the age and the offense that's committed. If that's the older, one of the big 14 offenses, those typically start in the criminal division. But the youth could be charged in some instances as an adult in the criminal division. The youthful offender proceeding is kind of a middle ground. It used to be called a blended sentence when it first got started because it has some of the juvenile characteristics and some of the adult characteristics. So if the person obtains youthful offender status, then they are treated as a juvenile in the family division. So they get confidentiality, the proceedings are confidential, they get the services provided by DCF, which aren't available in the criminal division. If they successfully complete, the record is sealed. It's never a public proceeding. And they don't have the collateral consequences of criminal conviction. So they get all the advantages of the juvenile treatment if they successfully complete the youthful offender program. If they don't, then the case gets sent back to the criminal division, and then we're treated as an adult, and they have all the collateral consequences of an adult conviction. As the public, if they have whatever impact on their life, that, for example, if it were a felony, then it could be related to housing, firearm possession, whatever, maybe all those things would apply. So it's sort of a carrot and stick approach. It offers the opportunity to the youth to have all the benefits of juvenile treatment if they successfully complete the youthful offender program. The way it works is, well, which cases get, or how does it work procedurally? And this helps to know because this will illustrate kind of what changes are proposed in H 642. But the way it works right now, the prosecutor can, there's two ways that a person can get to the family division for youthful offender treatment. The prosecutor can do what's called a direct file. So if the case is one that could have been filed in the criminal division in the first place, which means it's big 14, hence this little handout that people always ask, well, which are the big 14 again? If you want to keep that in file, there's the hand you'd reference, so you have 11 on the first page and 3 on the second, and that's because you may recall, now it's the big 14, it used to be the big 12. A couple of years ago, you took one of the original 12 off, hence that 11 on page 1, and that's just the copy. Right. And then you had the 3 that were added on it. So those were the 14. So one of those cases ordinarily starts in the criminal division, but the prosecutor can, before filing in the criminal division, thanks, and instead direct file in the family division as a youthful offender proceeding. So that's one way to get started. Another way is by transfer for the criminal division. So it could get transferred down as well. So, but either way, whatever way it ends up there, the first thing that happens is what's called a youthful offender consideration hearing. So that's the first thing that happens in the family division, this consideration. And that's when the family division is deciding whether or not the case is going to be treated as a youthful offender case at all. First question is always public safety. Will public safety be protected by treating the youth as a youthful offender? If the court answers yes, they proceed to a second question, which is 2 other questions actually. Is the youth amenable to treatment as a youthful offender, and are there enough services available? The court answers yes to both of those questions, grants the petition, treats the person as a youthful offender, and then it has a second hearing known as a disposition hearing. And at that hearing is when the court decides, well, what's the case plan going to be? What's the disposition case plan going to be? And it imposes conditions of juvenile probation. So that's the background, and there's a couple of proposed changes to each of those steps that I just described that are in H 642. So what's the first one? Section 1. This has to do with, well, whatever, as I just mentioned, at that second hearing, the disposition hearing, the court imposes conditions of probation, juvenile probation. So what happens if the youth violates those conditions? Well, options to the court, turn for a quick second to page 2, line 3. See, the court has several options. If the court finds after the hearing that the youth has violated the terms of the youth probation, and this is all related to youthful offender repeating specifically to the youthful offender chapter, the court's got those options. A, could maintain the youth status as a youthful offender, but modify the probation conditions. It's one option. B, could revoke the youth status as a youthful offender, transfer the case to the criminal division for sentencing. Remember, that's what I mentioned, that sort of stick approach. If the youth, if they don't complete their case plan, well, then it could get sent back to the criminal division.
Well, Eric, are you going through the changes on page 2 or are you,
No.
you're on lines 5?
Exactly. Just at the moment, just looking at the existing options that the court has if the youth revoke, the youth violates. And the last one, the court can just transfer supervision to the Department of Corrections. Because currently youthful offenders have sort of a joint status, both DOC and DCF work together and they jointly supervise the person. And they decide between themselves who's going to be the lead on the case plan. All right, so again, keeping that in mind, turn back to page 1. You think about what the other thing about youthful offender status is generally available up until age 22. But think about a situation where the youth violates at age 21, and the court only has jurisdiction until the youth is 22 years old. If the youth violates at a time when it's close to age 22, they could age out before the end of the proceeding. The court's thinking about, well, we just looked at what the options are, right? The court's not sure, thinking about what to do. There's been a violation. So, the new language on page 1, lines 15 to 20, what that does is it says notwithstanding, and that cross-reference, I think is a terrible. I think that B should be hit D. I was looking at that last night. That's on line 15, page 1. I'll confirm that, but I think that's a typo. But the idea here is that, well, we're going to let the court extend jurisdiction past age 22 in those particular situations. There's been a violation, and you'll see the motion for the revocation of youthful offender status. That's line 16. That's pending. So the prosecution is filed. There's been a violation. Prosecution files a motion for revocation, but the youth might otherwise age out of the court's jurisdiction, like if they were 21 or something. So the idea is, when you look at the second sentence, family division may extend its jurisdiction over youth beyond the youth's 22nd birthday to the extent necessary to maintain jurisdiction under this subdivision. So the idea is to allow the court to keep jurisdiction over the young person.
And remind me, Eric, if they were to age out, they would just go to the criminal docket?
Yeah, I think so. Yeah.
Getting your shaking here. Is that
Or maybe not. I'll let Kim clarify whatever.
Could you just?
Sorry,
Yeah.
sorry. Kim McManus, Department of State's Attorneys and Sheriffs. If they age out, the case just closes. Right now, it doesn't go back to the criminal court. That's why
It just gets
it just closes.
Going to be refiled. Disappearance.
It would depend on the statute of limitations.
Oh, right, sure.
And that's the issue that's being addressed.
Got it. Okay. Thank you. Wanted to Senator West.
Yeah, Eric, when you say it's going to be extended beyond the youth's 22nd birthday,
Right.
what's the cap on that? I mean, is there a time frame beyond the 22nd birthday, or?
I think it would be sort of qualified by that last line on line 20, to the extent necessary to maintain jurisdiction under this subdivision. So it's only for purposes, in other words, it wouldn't be indefinite. It would be for purposes of resolving this violation of probation motion.
Thank you.
Yep. So that's the first proposed change. Go on to, we're in the same section of law. We're still in the proceeding involving the violation of conditions of probation. Now we're over on page 2. Remember, we just went through what the options were in existing law for the court about revocation, transfer to the criminal division, etc. And what subdivision 2 says, add some criteria that the court would consider when it's making this determination under subdivision 1. In other words, when it's thinking about, when the court is considering what are the options now that the use has violated, did I just keep it, keep the case, should the case stay in the family division as a youthful offender, but modify conditions? That's option A, line 5. Or perhaps the youth status should be revoked, the youthful offender status should be revoked, send the case to criminal division, whatever the options may be. What subdivision 2 says is, well, when making that decision, the court shall consider, and then it lists some items to consider. And what those are essentially, A, B, and C over on the top of page 3, are the same criteria. I mentioned this at the beginning of my walkthrough. Those are the same criteria that the court considers when deciding whether to grant youthful offender status in the first place. So it's similar to the court basically saying, all right, is the court still qualify under those criteria that I evaluated when the initial motion for YO status was filed? So look at subdivision A, line 16, using the criteria of subdivision 528042, that's the public safety determination. Whether public safety will continue, that's line 17, will be protected by continuing to treat the youth as a youthful offender. In other words, it's whether those criteria are still being met now that there's been this violation. Subdivision B, whether the youth continues to be amenable to treatment as a youthful offender. Over on page 3, whether there continues to be sufficient services in the court system, juvenile court system, and DCF and DOC to meet their rehabilitation needs. So it's sort of a reevaluation, relooking at those same criteria now that there's been a violation, so the court can consider, hey, is this still an appropriate YO case or not?
So do they previously look at whether or not there's sufficient services in the first place?
Yeah, all 3 of those are pretty much verbatim from that initial decision about whether or not they're going to grant YO status.
So why? Actually, disregard. I'll ask this question in April.
Okay. So the second piece of new language there on page 3, which is subsection B, starts at line 4. This has to do also with the revocation process and the violation. So the youth has violated their terms of probation, and the court schedules a hearing, revocation hearing. And this basically provides that if the youth then fails to appear at the probation revocation hearing, so the court sent this, there's been a motion filed for revocation of probation because the youth violated, and the court sets it for a hearing, but the youth doesn't show up, then this provides the court with the authority to have the youth transported to the court for the hearing. You see that unless it finds there was good cause for the failure to appear, the court may issue an order, and not shall, by the way, with the may. So it's not required, but the court has the authority, if it thinks it appropriate, to issue an order pursuant to section 5108C for an officer to pick up the youth and bring the youth to court. So that language that's being cross-referenced here, just so you can see that it's an existing provision in the juvenile statute generally that provides the court with the authority to make an order like this.
So I'm curious as to the language of
So look at the language that's being cross-referenced. It's in the handout that I just passed around. It's in subsection C. It's the very last clause. This provides the court with the order to issue an order for an officer to pick up the child and bring the child to court. So the court has that authority now proceedings already. And so the idea here is to cross-reference that and say, if the court, if a youthful offender doesn't show up for the revocation hearing, then the court has the authority to issue an order for a law enforcement officer to pick up the child and transport them to court.
and these types of warrants can already be issued for what again?
It's a general statement of authority in juvenile proceedings. It's in the juvenile chapter. So as far as what circumstances the court uses them for, not entirely sure.
Yeah.
But you want to ask the practitioners that question, but it's a statutory grant of authority that the proposal is to cross-reference that existing authority.
Yeah, no, that's what I'm trying to get at is what other situations might
Right.
these warrants be issued, because it's a big deal to show up at a, that's a teenager showing up at their high school and taking them to the police. That's impactful.
Right.
And so I'm just curious as to where, it's a question for another witness, but trying to figure out how often this is used and in what situations. Did you have a question, Sam? Please.
But yeah, I think you have other witnesses, so hopefully we'll be able to talk to you about how that works in practice currently. All right, so that's the end of the piece regarding probation violations and revocation proceedings. So now moving on to another topic within youthful offender proceedings, and this involves victims' rights. And currently, in criminal proceedings generally and in juvenile proceedings as well, victims have enumerated rights to attend the proceeding, to express their views, to sometimes make a victim impact statement, that sort of thing. And those rights do exist in youthful offender proceedings. You'll see at the very bottom of page 3, the section of law currently is entitled Rights of Victims in Youthful Offender Proceedings. So there is a provision on that currently. But the way the current victims' rights in youthful offender proceedings statute is written, may remember I mentioned that there are 2 sort of stages at which a court has a hearing in a YO case. The first one is the consideration case. That's where the court decides whether or not to grant YO status at all. And the second is the disposition hearing. And that's when, after the court has already granted youthful offender status, the court's deciding, all right, what probation conditions should be imposed? What's the disposition case plan going to look like? That sort of thing. That's the second one. The way the statute is written currently is victims' rights occur at the disposition hearing rather than at the consideration hearing. And the proposal here is to permit those same victim statements to be made at the consideration hearing as are currently made at the disposition hearing. I think the thought behind that was when it happens at the disposition hearing, the decision has already been made. That's about equal offender consideration. So if you're going to have the victim provide input as to whether or not the person should get YO status, it has to be made at that first hearing, not the second one. So that's all the language does in several different instances. So for example, if you look at page 4, the current statute says, hey, it's enumerating these victim rights to appear in lines 9 to 11, for example. It says to be present during all court proceedings, specifically to attend, and the way it says now, to attend the disposition hearing to present a victim impact statement. Again, that's when the decision has already been made about granting youthful offender status. So it adds to attend the hearing on the motion to consider youthful offender status and the disposition hearing, so that they would have the authority or the ability to attend both of those proceedings.
At what point in an adult proceeding would a victim impact statement be considered?
I'm not sure that, but I could look at specifically what stage of the proceedings they have that. Right.
Thank you.
Yeah, sure.
Your question was when in a criminal case are victim impacts considered, generally in sentencing. But I mean, if you're having a trial, then the victim is testifying. There are statements that they're providing. And I think Kim could also speak to that and get the count.
And this is a very sort of general, and I realize they're not exactly the same, but sort of from a stage standpoint, the disposition and sentencing are sort of the same stage of.
For YO, I'm not as familiar with YO. I don't think that disposition and sentencing are.
I know they're not the same thing, but they're sort of the same stage in that it's sort of the end stage. I see Kim is shaking her head, yes.
Yes.
No, I know they're not the same thing, and that's why I was sort of recognizing that it was a blunt comparison. Okay, thanks.
And there's several different instances of the same thing, but that's the same thing that's going on throughout that section, which is just providing the victim of the ability to appear and make those statements at the consideration hearing as well as the disposition hearing. I think that's it.
Okay. And so this,
Yep.
so if the victim were to provide a statement at the determination of whether YO is appropriate, let's point up the statute again. So when the judge is considering everything under 5284, which are all the components that they consider when making that determination, right?
Yes, exactly. Yep.
So some of them are, whether determining whether public safety will be protected, nature and circumstances of the charge, needs, mental health treatment and history of needs, substance abuse of needs, residential housing status, employment and educational situation, whether they comply with conditions of release, criminal record. Action, actions, mainly. So in that type of determination hearing, what other witnesses could be called? Actually, this is probably another question for Tim. So.
Or the court, or both.
Yeah, right. Yeah, I'll just hold that question. Okay. Any other questions for Eric? Thank you, Eric.
You bet.
Next up. Yeah.
Good morning.
Oh, yes.
I'm going to defer the chair. Good morning, everyone. Tim McManus with the Department of State's Attorney and Sheriff. Thank you for taking up H642. If anyone happened to see the bill as introduced, it was much longer. During its time in the House, it was greatly reduced. And the parts that remained, our department strongly supports. The issue we raised last year when there was a lot of time being spent talking about raising the age. We spent a lot of time in the House and a little bit in here just talking about issues that have been spotted in the delinquency proceedings and also YO proceedings. And one of the big issues that we talked about was this aging out issue. And essentially that even if a youth have not finished their probation, even if they have a probation violation pending, if the state's attorney has filed a motion to revoke their youthful offender status and want their case to go back to criminal court, if the youth does not show up to those hearings, and or so by whatever means reaches 22, the family court loses jurisdiction at 22 and it's done. So even if we find the youth at 22 plus 3 days, the juveniles, even if they wanted to, they can't do anything at that point. They don't have jurisdiction anymore. And so we had a few ideas that were part of the original bill, like you do have the revocation hearing without the youth there. Essentially, can the family court send it back to the criminal court if someone doesn't appear? And a lot of due process issues were raised, understandably, with that. We like for the person to be in the room before we make any of these major decisions. So the idea here is, yes, we need that person to get back into family court to have a decision made, but let the family court extend jurisdiction so that we can finish that case. There's question, Senator Norris, of how long this would last. Potentially, it could last a while. If somebody is out and there's a pickup order that's written in here, or an arrest warrant, it could be that the person's 25, 26, and it's picked up. They're like, oh, you have this family court proceeding. And yes, this imagines that you would go back in to family court and then say you had this pending revocation. And at that point, the court can do two things. The court, as it's written here, the court can either discharge the juvenile on probation, find out what was going on in the remaining time, and make a decision that, this is done. We're just going to discharge from juvenile probation, and the case would be closed as if it was discharged when the person was 21. Or the court at this point could revoke the full offender and send that case back to criminal court, at which time the person would then be sentenced for the criminal charge that they had in youthful offender. So as a department, we support that. These aging out situations, are they happening every day? No, but they do happen. And we have to remember that the cases that are in youthful offender are some of our most concerning public safety cases. I'll give you just one example. Sorry, my computer, this needs to be turned off. Let's give you one example just to put this in real terms. So this was a scenario from last year that one of our juvenile prosecutors provided me. Case was an aggravated domestic assault. The person was 19 years and 4 months at the time of the offense. They were charged and arraigned the same day in criminal court. They were accepted as a youthful offender 3 months later, so still 19. At age 20, they had their disposition, which you're absolutely right, Senator. The disposition is the rough equivalent of sentencing. So as a youthful offender, if you had a merits hearing, it would be like your trial. It's a bench trial with the judge. After that, the judge would give you your disposition. So what you need to do to fulfill this. So I'm 20 years old. This youth had their disposition. 2 violations of probation were filed. They happen to be for new charges out of state, missed probation officer meetings, failed to complete programming. The youth absconded from supervision, was arrested out of state, was released, returned to Vermont, but then absconded again. An arrest warrant was issued, never appeared in court again, and they aged out at 22 with the arrest warrant still pending. So that's the scenario that we'd like to finish that case. We'd like to have a conclusion to that. We want youth going in to know you need to finish this. As Ledge Council stated early on, there's a lot of benefit to being put into the youthful offender program. And the major risk is that it could return to criminal court and you could have your criminal sentence. But if you're going to have the benefit of youthful offender, you need to know that there is a hard stop on the end. And right now, there is not.
I'm not sure if I'm confusing things or, so if somebody ages out and you said earlier the charges are dropped, or the charges disappear at that point.
The case closes.
Yeah. Can it be refiled as an adult criminal?
So that question was raised and I don't believe so. And I would think longer on it. If they went through and had their merits hearing, I think it would be, I think we would have essentially tried the case. I don't think we could refile it. But I would really need to think on that a little bit and maybe the court.
So there would be a merits hearing if even if he doesn't show up, the kid?
No, so if for youthful offender, just like a delinquency in family court, instead of a trial, you have a merits hearing.
Right. So I'm trying to figure out that so there's the merits hearing, and then I guess I just got confused how it's. I don't know, maybe I just got confused here with us, this question, but, I guess.
I think the question, if I understood it, and it was similar to one given to legislative council, was if you go through the whole process.
Yeah.
So you've had your consideration hearing for useful offender, the court says, yes, you should go over to useful offender. That just sends you over into the useful offender lane. You still have your right to have a merits hearing, to see whether the state can prove that you did what we're alleging that you did. You can also make an agreement, just like in criminal court, essentially a plea agreement. You can agree to what your disposition will be. Whether you agree or have your merits hearing, if the court finds, right, proof of the allegation, then there's the disposition plan, your sentence, so to speak. You're then on juvenile probation. So I believe the question was, if the person then, if the case closes without resolution, would we then go back and file again in criminal court? I don't think so.
Okay, so it's a unintended loophole in the law that allows somebody to just block.
Currently,
Yeah.
yes, and that's what we're trying to just.
Yeah.
Put that parenthesis on there and just have that, and again, this doesn't happen a lot, but it happens enough that it's frustrating. For sure to the state's attorney, I imagine it's frustrating to the court. And it's something that for, and I'm not saying every youth could fall into this, but for a more savvy youth, they would know eventually, names animated out. Not much is gonna happen until the revocation hearing, when the court can send you back to criminal court, and that's when the big consequence comes. And currently, if it can't go back there and you hit 22, then the criminal court doesn't have jurisdiction, the family court doesn't have jurisdiction.
So if you're getting close to being aged out, why can't you have a revocation hearing in order to avoid the loophole? Is it because you have to meet all these other elements?
No, you can, so say you just turned 21 and I'm seeing probation violations left and right, I can file a motion to revoke. Court can schedule that hearing in a month. You don't show up to that hearing. You don't have the revocation hearing, the court will not revoke you without you there. We reschedule it. The court orders a pickup order. 6 months go by. We still can't find you. And then the clock runs out. Can be, it could either be unintentional, but then the other issue is folks move around, they move out of state. Again, how invested they are in finishing their juvenile probation. There could be a million reasons why. We just want there to be an ability to not have this loophole. And for individuals who are following their juvenile probation and doing all the things they need to do, this is not going to impact them.
So so the folks who are, at the cusp of that age, they've had their disposition and they're gonna be 22 soon. There's no risk of them, of having their juvenile probation turn into regular probation or having to deal with criminal court if they've got a couple of years of probation going into their mid-20s.
Well, so part of the consideration at the front end for the court is, do I have enough time to work with this person? So say someone comes in at 20 and youthful offender is an option. The court is going to run through that analysis and see again the services, public safety. Can we work with this person? If it's a situation, and I had this scenario where it was a youthful offender consideration hearing and the charges were sexual assault. And the defense had testing done, for the youth, and the, doctor came back and said, yes, we can work with this youth. It would take 2 to 3 years of treatment to work with this youth. And so then the argument became, is there enough time? Due to the youth's age, will we have enough time before 22 for this to be successful? And the court found that there was not enough time. So that person was not eligible. So in the scenario that you just raised, if it's an older youth, that's a big question there. If it's something like, oh, they need to be on probation for a year, they need to do anger management training, they need help getting a job. If the court views that as a disposition that's doable and the youth is doing everything they need to do, then we don't see this. This isn't gonna extend probation. It's the question of if they start violating their probation. At that revocation hearing, the court then has, as Lynch counsel ran through, a few options. So say you're 21 and a half and you have a revocation hearing and you're before the court. And the court can say again, you know what? I think they've done as much as they can do. We've done as much as we can do. I'm discharging probation. Or it can say, you know what? We have 6 months. I'm going to modify your probation. And this is what I want to see in the next 6 months. Or it could say, this isn't working. I'm sending this back to the court. So while the court has jurisdiction, they have those options. And again, specifically written in here, if it's over 22, and we've extended that, there's 2 options, discharge or revocation. So there wouldn't be putting you back on juvenile probation at the age of 25.
Thank you. That's helpful. Senator, so
Yeah, so in an instance like the one that you just described where someone could have been successful or perhaps went in and was doing well, but not quite there yet, could this be used to extend that time in that instance?
No.
Okay. So it can only be used in an instance where someone is not like if someone just needs a little bit more time to complete whatever.
Well, so again, I apologize. That was a quick hard no. Meaning again, if someone's doing well and he's at that 21 and a half and then maybe hasn't ticked all the boxes, the question is more, again, the court, we wouldn't be filing a motion to revoke if they were doing well.
Right.
Right. So we wouldn't be asking for that. Yes.
Okay, maybe I need to spend more time with the language.
It's if you're violating your probation. So if your probation conditions were, you need to go to treatment, you need to go to school, or you need to be working, you need to go to therapy. If you are blowing off your therapy appointments, we would file a motion, possibly.
and there's some, you just got to what I was getting at with the discretion for the possibly. So, somebody misses a therapy appointment because their car genuinely broke down on the way to the appointment. But they missed the appointment, which is technically a violation of probation. You folks, your office has a discretion after consulting with the PO to say, this was a genuine issue. We don't need to violate this person, right?
Yes, and similar to adult probation, we're getting our information from their juvenile probation officer, who is usually a DPS worker. So they're informing us, and we're not going to know every missed therapy appointment, but we'll get, God bless you, an email or a phone call. Johnny has missed 4 appointments in a row, and just missed a probation meeting. Okay, and then usually it's the DCF worker saying we need to do something, and then we would file. And it's not always motion to revoke. Is not generally our first option. Usually it's a motion for a probation violation. Maybe something needs to be modified in the order. Maybe the youth needs to be in front of the judge to be reminded of what their responsibilities are. And again, for this extension of jurisdiction, this would only be for a motion to revoke. If that was something cleaned up on the House side, it wouldn't be a motion to modify and asking for additional time. as a juvenile petitioner.
I also had a question about the witness, or I'm sorry, it's a victim testifying at the determination hearing. And can you share what other witnesses get called to testify? Yeah,
At the consideration hearing.
or yes, the consideration.
So as in the example I gave, it might be a doctor or a therapist. If there's been any testing or evaluation of the youth, as far as what treatment might be possible. It is often the DCF worker who has done any, again, screening analysis of what programming would be available. Sometimes it is the, we may bring in the police officer if we're talking about, you know, the seriousness of the crime.
So
Sometimes.
I guess-
yeah.
So I guess my question is why, you know, those sound like witnesses with personal knowledge. Why wouldn't, under current law, why wouldn't the victim be able to testify as to the seriousness of the crime or any other personal knowledge they might have for the youth?
So what's interesting there, and this again, this is a piece of legislation that we suggested needed clarification, is that we have different, we're seeing different analysis of that assumption of the state. Some judges do let the victim speak at the consideration hearing, some do not. And so the way it's written, it can be interpreted either way right now. And we asked for this to be clarified, that the victim can speak at that time, and that the judge can consider that in their analysis.
Thank you. Any other, Blackley, do you have any additional testimony?
Just for the first part, that took up a lot of our time. For the victims' rights, again, we do support that it's clarified that they can speak at that initial consideration hearing. And we do think the victim's perspective is important in terms of the public safety question. As the court runs through whether this person, whether the youth charged with the offense is appropriate for useful offender, whether public safety will be maintained is the primary question, and then there's another set of considerations. And we believe that the victims or the victims in the case, their perspective on their own safety, whether their safety will be protected as this person being a useful offender, is a factor that the judge should consider, and that only the victim can speak to that.
I believe Senator Morris had a question.
Yes, I'm clearly confused about all this. Using the example that you gave, you had stated that they could ask for jurisdiction beyond the use 22nd birthday, but then said that 22 case closes. Does the pickup order remain in effect? Because you went on to say that at age 25, they could enforce that and then bring that individual at age 25 back to family court versus a direct route to criminal court?
So right now, so without the bill, taking this bill away.
Yeah.
Right now, if there was a pickup order and the youth turns 22, that case is closed, that pickup order would be useless. That you would not, if you found the youth 22 plus 3 days, the family court could not hear the case. So that's right now.
Yeah.
With this bill, what we're asking is if there was that pickup order at 21 and we can't find the person, this would allow jurisdiction to extend past 22. So if you did pick that person up at 23, 24 years of age, this would allow you to bring that person back
To where?
to family court.
Wow.
Because their case isn't done. They haven't finished it.
Right, but you said during this process, they've already committed a couple more crimes. They've absconded a couple different times. They failed to, follow the youth process as far as being a youthful offender. Now age 24, 25, we're gonna pick them back up and bring them back to youth court, family court.
Yes, with the hope of exactly, because we need them to have that hearing in family court, that revocation hearing, and if the judge hears everything that's been going on, they have two choices. They can discharge the youth or can revoke and send that case back to criminal court. And then the youth would be sentenced on the underlying charge. And that's what we're trying to get to for those few individuals. Because right now, nothing.
That's great. Yeah, charges just go.
Let me just text my notes quickly.
Thank you.
Thank you.
Next up, we have Judge Donay. Did that say what time is it? Okay. Well, we did switch.
Good morning. I'm Chief Superior Judge. So with respect to H 642, on page 1, line 15, it says notwithstanding subdivision 5103 C2B. I believe that is a mistaken reference. It should be D as in David. So beyond that, it is a policy. Ms. McManus explained the way it would work. All this does is it says if you are not, if there's a violation filed and you go by that 22-year age, you don't get to, if you will, take a knee, and if you don't get to wait out the clock, that it remains active. And then once you're picked up, you come back to court, the juvenile, in the juvenile case, the youthful offender case, and the judge decides in connection with that case, are you discharged because you're over 22 and you can't be continued, or are you violated going to the criminal division for the sentence?
The question I had to do with the authority to pick people up with the warrant. I don't think you were here when I mentioned this, but I'm curious if you could share some of the situations in which that warrant gets issued, because they're pretty impactful situations for sending the police to a high school for 15-year-olds to bring to court. Is it used often, or is it? I know it's at discretion.
I actually don't think that we have a lot of pickup orders on youthful offender cases like this. That's enough.
Any other?
Yeah, that's my watch. It's going off. I don't know how to turn that down.
Any other questions?
You're more important than my watch.
No.
You also had questions on another bill?
I did. I know we have Matt Valerio coming in at 10, and my hope was to hard stop at 10:15 so that we can hear from you regarding 329. But yeah, unless does anybody have any additional questions, the judge? No. Okay. So we can take 5-minute break, and then Valerio could hopefully be here at 10. We'll hear from him until 10:15, and then we'll come back to you for 329.
That's okay.